I think what we were referring to earlier, sharing how it's so hard to define when someone is an aguna, when someone is a get refuser. And I think by and large, in the modern Orthodox community in particular, it's become unacceptable overall to be a get refuser. It's not something that someone wants to be, which is great. But one way that someone can do it, but in the shadows, is to engage in get delay, to say, of course, I would never withhold a get, but I'm just going to do it on my own timeline. And that
I'm
is
just
within
following the
halacha.
Ramah.
I'm just following halacha. Exactly.
I'm Scott Kahn, and this is the Orthodox Conundrum. This is the Orthodox Conundrum on JewishCoffeehouse.com. I'm Scott Kahn. Today's episode deals with a topic that many people have heard about, but far fewer people actually understand properly. Terms like get refusal or Seruv are often mentioned, sometimes with strong reactions, but often without a clear sense of what they mean in practice. So in this conversation, we're going to take a step back and try to understand the system itself. What exactly is a Seruv? How does the Beit Din process work when a couple is going through a divorce? At what point does a difficult or contentious situation cross the line into something more serious? And where does the system function as it should? And when does it sometimes break down? My guests today are Jen Lankin, co-CEO of ORA, the Organization for the Resolution of Agunot, and Rabbi Jonathan Hefter, ORA's Director of Partnerships and Innovation. ORA works closely with individuals navigating some of the most complex and painful cases in the Jewish divorce system, and they bring both practical experience and a broader perspective on how these situations unfold. One of the most important ideas you'll hear in this episode is that these situations can become complicated very quickly, but that complexity does not change the underlying reality. When a get is being withheld or used as leverage, that's a serious breach and problem. And understanding how and why that happens is essential if we want to address it effectively. We also talk about concepts that are not always part of the public conversation, like get delay, the role of community responsibility, and an emerging view that the get may need to be given earlier in the process in order to avoid becoming a point of leverage. And just as importantly, we discuss the idea of survivor-led advocacy. Public pressure, including rallies, protests, and communal action, can sometimes be effective, and ORA does use those tools. But they're not always the right approach, and even when they are, it's essential that the Agunah herself is the one guiding that decision. The process matters, not just the outcome. And supporting someone through this kind of situation means ensuring that she retains agency over how her case is handled. This is a serious and unfortunate topic, but it's also an opportunity to better understand how the system works and to think more carefully about how we, as an Orthodox community, respond when things do not go as they should. And we'll get to that conversation in just a moment. First, I want to let you know that this episode includes a bonus question available exclusively to paid subscribers of Orthodox Conundrum Commentary on Substack. In that bonus segment, I ask a question that puts a different spin on the issue that we're discussing today. When it comes to get refusal and the Jewish divorce process, is Israel actually better, or does the Israeli system create different problems? After all, the Beit Din has real legal authority in Israel, but as you'll hear in the bonus question, that doesn't necessarily make things simpler. To hear that full discussion, ad-free and with early release, you can become a paid subscriber to Orthodox Conundrum Commentary. The link is in the description of this podcast. Remember to subscribe to the Orthodox Conundrum podcast wherever you get your podcasts. Please rate it and write a review. Continue the conversation on Facebook by joining the Orthodox Conundrum discussion group. Finally, the best way to promote your organization, your business, or yourself is to create a high-quality podcast, and JCH Podcast Productions can help you make that happen. Whether you want to learn how to start your own podcast or want to improve the podcast you already produce, we will make it happen. Write to us at aliza@jewishcoffeehouse.com. That's ALIZA @jewishcoffeehouse.com. And let's get started with your high-quality, memorable, and effective podcast. Jennifer Lankin is co-CEO of ORA, where she has worked for more than a decade in roles spanning education, development, and operations. She now oversees communications, strategy, and organizational leadership, guiding ORA's work to prevent get refusal and support individuals navigating Jewish divorce. Jen has helped launch and expand several of Ora's key initiatives, including Cherut, Ora's global network of Agunot advocacy agencies, and Ora's campus fellowship program. She brings a collaborative, creative, and values-driven approach to leadership. Jen holds a BA from Yeshiva University and an MA from the Hebrew University of Jerusalem. Rabbi Jonathan Hefter is the Director of Partnerships and Innovation at Ora. A graduate of Yeshiva University with smicha from REITs and an MSW from the Wertweiler School of Social Work, Jonathan spent 10 years building and directing Ora's Jewish divorce helpline, One Step Forward. Having guided thousands of individuals through the complex challenges of Jewish divorce, he now focuses on deepening Ora's institutional partnerships and developing new avenues for organizational growth. He's a dedicated advocate for creating safe and supportive spaces for those in crisis. Jennifer Lankin and Rabbi Jonathan Hefter, thank you very much for joining me today on the Orthodox Conundrum podcast. When people hear the term Seruv, they often have a vague idea of what that means, if any. So let me ask you what a Seruv is in halachic and practical terms. At what point is it issued in the get process, if at all? And how does it function within the Beit Din system?
Yeah, and thank you so much for having us. To get us started, really, a seruv is an order of contempt, which is a ruling that a Beit Din can issue if someone isn't cooperating with their process. And so in Jewish divorce cases specifically, a seruv typically means that someone is refusing to give the get, or just as often, refusing to appear before a Beit Din at all. And so the consequences of a seruv are typically that a community is called upon to help convince the person who has a seruv issued against them to do the right thing and cooperate with the Beit Din. Depending on the wording of the seruv, that could look a little bit differently. There's something known as harchakot de Rabbeinu Tam. So in those situations, it would even call on the community to really distance themselves from the person who has this issued against them by not doing business with them, not including them in a minyan if they're a man, or really, giving them any honors in shul or anything like that. And when it comes to enforcement, there really is very little that can be done because outside of Israel, Beit Din function as arbitration forums. And so unlike civil courts, which can put someone in jail or penalize them in some way if they don't comply, a Beit Din doesn't really have that power. And I think for that reason, our role as a community becomes even more important because in effect, the onus is really on us to hold one another accountable. And so if we want to be a community without get refusers, we need to maintain a standard for ourselves where a seruv is issued, then, we agree to uphold it.
But let me ask about that, because you mentioned two different types of enforcement mechanisms by the community. One where it sounds more gentle, let's encourage him to do the right thing. And another where he's actually in a kind of cherem, almost excommunicated. He can't join a minyan, for example. How is it determined which one applies in any given case?
Yeah, so I think it really depends on what the specific psak ruling is. But typically it will say either you can distance this person from your community, but the way to go about doing that really varies from community to community. And so it kind of gives the permission to a community to determine, even though they sound like complete opposites sometimes, but to determine what is the best course of action here. Are we more likely to convince this person to give a get by kicking them out of shul? Are we more likely to convince them to give a get by calling them on the phone and asking them what's going on? There are certain things that we definitely cannot do. We can't welcome them in our community and treat them as if life is normal because that wouldn't be okay. That wouldn't be fair. It wouldn't be just for the situation. But beyond that, we can also engage in certain ways if we find that that can actually be helpful in resolving a case.
Let me ask then, and I'm sorry to continue on the same track, except there are so many questions that I have about how it works. We see in practice that that's not what often happens. We see people who have a seruv issued against them being welcomed into perhaps not that community, but into other communities. And sometimes even with the knowledge of the people there. So halachically, where are they coming from to the degree they care about halacha? Because they often at least appear to be Orthodox communities. Why are they welcoming a person who has had a seruv issued against him into their community without any of these elements of trying to convince him to do the right thing?
There are some situations where people are not aware that there is a seruv out there. That definitely could happen. But if there is knowledge about a seruv, then it really would be violating halacha to not to comply with it. That said, is there an enforcement that can happen if someone is welcoming someone into shul? Probably not. And that's why organizations like Ora in some ways are kind of an enforcement arm for Beit Din, because without the Beit Din's ability to really do something, if people are not upholding their own seruvim, it really becomes the role of each individual community rabbi or community member to say, I'm actually going to take the step of kicking this person out of shul or saying that they're not welcome, which is really difficult to do.
Okay, I understand that. Let me ask another question about Seruv. Is there a possibility of a Seruv being issued where the recipient is actually not incorrect to have refused? For example, there might be an argument between, in this case, let's say a husband or a wife, about which Beit Din to use. And it's not that he wants to be a get refuser or that he doesn't want to go to Beit Din. He, for example, let's say, is coming from a Dati Leumi or modern Orthodox perspective, and he wants to have a Dati Leumi or modern Orthodox Beit Din, and maybe the wife went to a Haredi Beit Din, and they simply disagree about which Beit Din to go to. So a Beit Din issues a Seruv, but he's, it seems, relatively innocent. Is that possible?
Really good question. In a situation like that, it's unlikely that there would be a seruv. So just to kind of take a little bit of a step back, because this process is so complicated, when someone has a summons, what's known as a hazmana, sent to them from a Beit Din. So let's say, for argument's sake, a wife initiates a divorce process, she calls a Beit Din, opens a case with them. They send a hazmana to her husband. Halachically, he has two options for how he can respond. He can either say, okay, I'm going to show up, or I'll deal with this issue, but I don't want to do it at the Beit Din that you chose. It's kind of exactly like what you were saying, right? Maybe it's not the right community or any reason. He doesn't really have to, prove that halachically. That's totally okay. What's really complicated is that this initiates a halachic process that essentially creates a new ad hoc Beit Din that only exists for the parameters of their particular case. It's called a zabla, which stands for Ze Borer Lo Echad, V'Ze Borer Lo Echad. And so let's say the first Beit Din that the wife chose, she chooses one dayan, one judge. The husband then chooses one judge to represent him, and then those two parties come together and select a third dayan, a third judge, and they create that new ad hoc Beit Din. And so in a situation where a husband says, I don't want to go to the Beit Din that you chose, there wouldn't be a seruv issued against him. However, this is actually where a lot of ORA's cases live, because this is a very complicated process. There's no governing body that determines if a specific Beit Din is reputable or not. So theoretically, the husband could say, my neighbor and, my friends and this other person, I know they're my Beit Din. And so that can be, that can cause problems. Or two well-meaning dayanim from really different communities can take a really long time to find a third party to sit with them on that panel and create this new court, essentially. And so what we sometimes see is that although this is a halachically valid process, it often is a way for someone who actually really knows the system well to delay the process. They could say, a Beit Din has issued a hazmana and a second one, but before the third one, before a seruv might even happen, I know that if I say I want to initiate this zabla process, then I can pretty much indefinitely delay anything from continuing without the fear of a seruv being issued against me.
That's very interesting. So a zabla isn't just one of the options on the table. It's actually, it sounds like almost an automatic option when they have this kind of disagreement of where to go.
Totally. It's totally valid.
Now, in theory, the Beit Din system is meant to guide Jewish divorce cases in an orderly way, in a fair way. So at what point does that system work as intended? And in the example you just gave, it's one case. Let's talk about other cases where it tends to break down.
Scott, that's an excellent question. And I think that in order to address it, I'll follow up on what Jen just mentioned. If we look at the Beit Din system, if we call it a system, it's important to understand that really outside of Israel, there is no unified system like there is in Israel in terms of the Rabbanut. Instead, in many places, and especially in the United States, where we have the majority of our cases, there can be multiple unrelated Beit Din, even in the same city. On top of that, even in a jurisdiction where there's a Beit Din Kavua, there are no standard rules and procedures that each Beit Din must follow. Clearly, they abide by halacha, which itself, there can be various opinions, but many aspects of the process in a divorce process touch upon community norms, upon different cultures and particular sensitivities. And so the process works as intended when there's a Beit Din that is systematic about the process, clear about how the divorce should look and proceed, and where both parties are relatively willing to cooperate with each other. The couples can come to the Beit Din, do the get, and mediate the different issues in the divorce. At ORA, we unfortunately see mostly situations where the system has broken down, but we know that many gittin and or divorces are handled very well in the Beit Din system or Beit Din process. That being said, this process of the divorce and the get, many people are unfamiliar with it, and they don't really know how to advocate for themselves. Being in an unfamiliar space makes it really hard to avoid missteps and complications. So the breakdown, just to give a few different examples, I'll share three that we witness most often at Ora, is number one, either the Beit Din doesn't send the hazmanot, the invitations or the summonses, in a timely manner. If they delay and they don't pursue the defendant in a divorce case, which mostly is a husband in our cases, but it could be the wife, then the plaintiff can lose faith in the system or can become very frustrated by the time that's going by as they're waiting. Another way, in addition to not sending the hazmanot, a Beit Din, we unfortunately see this often, can encourage or even tell the wife, for example, to remove an order of protection or something important that she has from civil court in order to begin as a prerequisite to begin the get process. So we understand the different opinions about going to civil court and issues that involve our codes. However, when somebody has gone to the authorities for protection from an abusive spouse, it isn't fair and it's not always possible to make them choose. And hence, the Beit Din process comes to a halt. It breaks down because of this conflict between continuing in the Beit Din, but also having to do something which may not even be possible in the civil court. In terms of individuals, the process can also break down by delay, right? A husband, as we often see at ORA, will delay in the response. He'll play games by naming different Beit Din or just not showing up. And time goes by, and that breaks down as well. There's a lot of wasted time and a lot of frustration. And eventually, unfortunately, people will give up.
I want to ask about that second reason you mentioned, Jonathan. When you talk about a Beit Din asking you to remove an order of protection, why would they want to do that?
So there could be various reasons. So the most common that we hear from the callers that we get at ORA is very much because they're uncomfortable. They say, "Well, I don't want to have that order of protection. It wasn't true, or
Meaning the
maybe it was
husband.
true." The husband, usually, in our cases, but it could go either way. They'll say it wasn't true, and this is my method. This is a great piece of leverage to say, "Well, take that away, and then I'll come to Beit Din, and then I'll cooperate. But until that's taken away, I'm not moving. I'm not budging."
That leads to another question, and this is very big, and perhaps it's its own podcast. So if you don't really want to address it right now, I understand. But when you say that he uses it as leverage, and of course, a lot of get refusal is about leverage, it seems from what I've heard, and you can tell me if this is right or wrong, that's really my question, that the Beit Din are so intent on getting that get, which means it's done in a noble sense. Very often they will sort of agree with the husband, not morally, but if you only give greater custody, if you only would give some money, if you only would do the following things he's demanding, we could get you out of being an aguna. So why don't you just do that? It seems to me, from what I've heard, that happens a lot, and I think it's very troubling. It's coming, I believe, again, this is something which I'm asking, tell me if I'm wrong, it's coming not from a male-centric positive place towards men, it's coming from let's get her free, but it also means that it's allowing people to use the get as leverage. Is that true? Is that a problem?
That's an excellent point, and it's something that we hear very, very often, and a question that we get a lot from callers and from community members, rabbis who call, even dayanim we speak to, as a quite a common approach that a Beit Din can take. I believe that at ORA, our response on one level is that we need to take the high ground. Is that if we allow the get to be used as leverage, if we don't all agree on some basic ethical standards, so then it's a wild west. Then you can make that claim in any situation you want. We need to stand on a principle, and if we're the Beit Din, if we're a Jewish organization, if we're a Jewish community, we can't go for the minimum. We have to go for the maximum. That's the first, I think, approach, and that's the high ground. In addition, on a practical level, it doesn't work. It may start out as leverage. It may start out as saying, well, just do this or just do that. However, the demands just keep coming. And we've often seen that if we give into one demand, there's just another one and another one and another one. And very often it's not about the particular thing, particular issue, a little more custody, a little less child support. It's about something deeper. And we have to expose that, and we have to resolve that and be able and allow both people to move on.
Okay, what does something deeper mean, for example?
I think something deeper very often is either something like not wanting to move on from the marriage, wanting to stay married, or some very, very deep hatred or being wanting to hurt the other person. We get many calls from women who tell us that my husband told me I'm not going to give a get until you can't have children anymore. And that's extremely abusive and extremely hurtful. And it could be somebody in their 20s, doesn't have to be somebody in their 40s. And so those things, those ideas are beneath the surface very often. And again, it's not in all the cases, and we're only seeing the worst of the situations at ORA. So you can't extrapolate to all the situations. There's obviously a range and a spectrum. However, that often is what's behind the refusal. There may be cases where that could work. And if that does work and a Beit Din is able to resolve half their cases that way, the Beit Din has to use their what they see, in front of them. However, from what we see at ORA, having that be the approach is not going to work.
Okay. At what point would you say that a contentious divorce has crossed the line into get refusal? It may be that the husband is not interested in refusing a get, and we're at a certain point in the divorce proceedings. He doesn't want to be called a get refuser. He doesn't think of himself as a get refuser. They're just arguing and they're not ready to get divorced yet. They have to figure it out. I realize that's a loaded question, which also would make some assumptions, but at what point is that line crossed?
I think this is such a good and important question, and in some ways the hardest, and in some ways the most foundational. I think it also calls to mind who decides who's a get refuser, who decides who is an aguna. I think for starters, I'll say from our experience at ORA and from the perspective of how divorce works in general, things don't happen so quickly. We know that things take time and there's a process involved. And except for rare situations, the get is likely not going to happen immediately. And it might not be for us to decide exactly what is that moment, what is that amount of time, where it should happen, but it should be at the top of everyone's priorities. I think in terms of someone being a get refuser, technically that's something that's determined by a Beit Din only if there is a Seruv. And so on the one hand, this would mean that a case already needs to get to a point where a couple has initiated a Beit Din process and is already kind of underway there in order for something on a technical level to be considered get refusal. And for us at ORA, we can only really advocate once that happens. But just putting that aside a little bit and understanding just really on the deeper level, where is this happening? I think that if someone wants to use the get for leverage, then that is when get refusal is happening. But I think something that's so complicated is even in cases that we have at ORA where someone is a get refuser for years, even decades, we'll often hear them say, get refusal is not okay, but I'm not a get refuser. In my particular situation, things are different because X, Y, and Z. And for that reason, I think that we have to just have a policy as a community. I think we'll talk about this a little bit later on, but that's why the timing of the get becomes so important, because it really removes the possibility for the get to be used as leverage. And if someone is well-intentioned, but they are saying, I'm happy to do the get just later on, we might want to question that and say, well, why? What are you giving up by doing the get earlier?
Jen, you and I talked about this a couple of weeks ago, and I'd like to address it now if it's okay, that idea that the get should be given at a certain point in the process, because you mentioned that traditionally many assume that the get is given at the end of the divorce process, but it seems that there's a growing push among some poskim, and I think among people in ORA, that it should be given earlier in the process. Can you just lay out the issues over there and why would be done one or the other? Why wouldn't it be done at the beginning?
Absolutely. Yeah. And I'll just reiterate, I would say the main impetus behind this shift is so that the get doesn't become entangled with any other issues or used as leverage. I think from a halachic perspective, there is this concept where the Rama essentially writes that a get should be done after the ketubah is resolved, meaning either the money is issued or the wife, relinquishes any of her rights to it, so that if a get was given beforehand, the husband can say, I gave it, but had I known that this would be the financial outcome, I wouldn't have done it. And so kind of in the spirit of that Ramah, there is halachic validity to doing the get towards the end of the process, so that a husband won't say, had I known how the financial, outcomes would be, I wouldn't have done it. But practically speaking, this really isn't an issue, because the way that the standard get procedure works, that pretty much all Beit Din, is where a husband has to say, I'm giving this get unconditionally, totally separate from the outcomes of anything else in this divorce. So I think in some ways, it's just what we're used to. It's just the standard that the get can happen later on. But there are a lot of challenges there because we've seen many situations where a get will be done at the very end of the process, or a Beit Din might even issue a judgment for everything else, meaning that they've already made decisions about finances or custody. And in that agreement, they'll say the get now has to be given within a few days or something like that. But there's no way for the wife to then enforce that. And even worse, we've even seen situations where the wife will try to enforce that in a civil court or elsewhere, and there will be negative repercussions for doing so, where the Beit Din might claim that the get that resulted from that pressure is not even valid. And so,
because a get given under pressure is not technically valid.
exactly, that it would be considered a get said. Exactly. And so the timing of the get is so critical because there's just no way to have a fair negotiation if one person has leverage that the other person doesn't have.
So this is going to be a contentious thing to say, and I don't believe it, but I know there must be someone out there listening and saying, wait a minute, divorce law is universally in favor of the wife or the mother. That's generally how it works almost everywhere. So therefore, she already has leverage, and you're saying the husband should have no leverage. Now, of course, we all agree get should not be used as leverage. However, someone might argue, so he has nothing whatsoever. He has to simply take whatever the courts give him, which is always in favor of the wife in his mind, and he has no leverage whatsoever. So he says, I'm not going to be a get refuser. I'm going to give the get right away. But then he says, fine, what can I do in order to try argue my case? Because once I give the get, I messed up. I get nothing now.
And that's something we definitely hear a lot. So I'm glad that you brought that up. I think there are a few different responses to that. The first is really just addressing that head on, which is that this is a very prevalent misconception, but time and again, it has been proven that it's just not true, that it is very rare for a court, pretty much universally, to give sole custody to one parent, so much so that if they do give sole custody, it raises serious questions about other allegations of abuse or other things that are going on. Even when crimes are committed, it's so rare for there to be, no semblance of joint custody. And the second response that we would give is that if someone wants to fight for a better custody arrangement, there are forms for doing that. If they want to fight for better financial settlement, there are other forms for doing that. And by all means, if they think that's in the best interest of their family and their children, they can do that. But the get is totally separate. And so enmeshing it in those negotiations creates a situation where the wife cannot fairly negotiate. And so keeping it off the table is really the only way to do that.
I'd just like to add something to what Jen just mentioned. In my role at ORA for over a decade, answering the helpline, I've spoken to thousands of callers, mainly women, however, many men as well. And there's so many times that I could be on one call in the morning and have somebody explain to me how the court favors one party and always favors that party. And then in the afternoon, I have a call with another person telling me the exact opposite. And I really have seen this to be true time and time again. There may be, in certain ways, this court, this specific jurisdiction, this judge favors one gender over the other, or this Beit Din one over the other. However, it can really cut both ways. And so taking the get out of that is very, very important.
Okay, thank you for explaining that. In terms of the common perception, the get refusal is an extreme case and very rare. I'd like to know if that's true or if it actually appears more often than people realize, perhaps in subtle ways that they may not consider get refusal. How often and how common is this that it actually happens?
That's also a great question, and I think it relates very much to the two tiers of advocacy that we do at ORA. We have a helpline, which is a general support line for people to call, individuals to call and get some general advice and guidance, information when navigating the divorce process. And then we have our case advocacy for what we call bona fide get refusal cases, or misorvot get agunot. And so although, let's say, our caseload at any one time is between 60, 70 agunot, we have hundreds of callers who are telling us about situations of refusal. They may not technically be, as we've been discussing, a situation where there's a Seruv or a Psak of a chiyuv get or something like that. However, it's very, very clear that there's been explicit and very often implicit messages that the get is not going to happen, or that the get will only happen if XYZ occurs. And so it is quite normal, or it's been normalized, and it is very, very widespread in many divorce situations. The question is why, right? The question is why in so many cases is it there in the backdrop? And I think it does touch on what mentioned earlier, which is it's seen as the single point of leverage. That on the one hand, the common assumption, at least within Jewish communities, you can talk about different parts of the Jewish community from the left to the right. However, in general, you could say that maybe that there's something that the Beit Din will favor in terms of child custody, or with the mother getting more, and then so on the flip side, the father needs to fight for something or use leverage, and so it's acceptable, and therefore many situations of at least that we hear about are situations where a wife will call and say, "I know that I have to give this up," or "I know that my husband has already told me the minute that I ask for a divorce, he's not going to give me a get unless." And so it's there already in the background, and it's already almost accepted. It's something which I know I'm going to have to deal with.
So there, just to add on to that, is that it's so tricky to remove the get with everything else in the divorce that is legitimate leverage, meaning that we, of course, don't think anything should be used or extorted in a divorce. But in general, if one person has more assets or one person has something else that they can use in their favor in a divorce, an attorney will typically feel that it is their requirement to say, this is what you have in order to have a better outcome. And so it's actually very multi-layered and complicated, and even includes education for attorneys and even judges to say everything is fair game except this religious document that isn't. And that's why it's sometimes just a natural part of the process where people assume that it's okay and maybe get bad advice early on.
Interesting. Well, this all leads to a different question about something similar, which I don't know anything about, namely get delay. And there's a difference between get refusal and get delayed. I'd like to know what it is.
Yeah, so I think get delay essentially is something that we're thinking a lot about at ORA, and language that we're really putting together. And essentially, it's the idea that delaying giving a get is kind of a way to be an invisible get refusal. And so what I mean by that is it provides a cover where a recalcitrant spouse can say, I absolutely intend to give the get, say at the end of the process once everything else is resolved. But the problem with that is that either there's no seruv against them, and there likely will not ever be one because they might be working within a Beit Din that agrees that a get can be done at the end of the process. And whether they're dealing with all issues in a Beit Din or in civil courts, that process can take years. Or, like in most of ORA's cases, there is a seruv against them because they refuse to show up, and they're telling their community and their friends and their neighbors that they're a really good guy and they would absolutely agree to give the get at the end of the process. But if they think that's a really good argument, then they can actually show up to the Beit Din and share that argument. And if the Beit Din agrees, then they can say, okay, we of course would not issue a seruv against you. You're right. It's appropriate in this situation to give the get at the end. And so I think if we really think about it, the only reason not to do the get early on is to have the option of using it as leverage later, which isn't something that we should really condone.
Right, of course. So it sounds like you're using the term get delay as a means of changing the binary, where it's either you are or you aren't. And it's, something, there's a big middle ground, which is still not acceptable, even if a seruv has not technically been issued. Is that correct?
Exactly. And I think what we were referring to earlier, sharing how it's so hard to define when someone is an aguna, when someone is a get refuser. And I think by and large, in the modern Orthodox community in particular, it's become unacceptable overall to be a get refuser. It's not something that someone wants to be, which is great. But one way that someone can do it, but in the shadows, is to engage in get delay, to say, of course, I would never withhold the get, but I'm just going to do it on my own timeline. And that
I'm
is
just
within
following the
halacha.
Ramah.
Just following halacha. Exactly.
in that case, that leads to a very interesting phenomenon and a very troubling phenomenon, which is that I'm assuming that anyone who's standing under the chuppah, at least the vast majority of them, neither of them has any intention of getting divorced and certainly no intention of being a get refuser in the future. Do you know, aside from leverage, is there anything else? I guess in a certain level, Jonathan, we talked about this before, but what's driving the behavior that can make a person who said, I would never do that, become a person who is completely doing that and justifying his actions? I'm not asking what the motivation is so much as the psychological switch to say that this is okay to do.
It's very true, and definitely not something that we even assume is in somebody's mind going into a marriage or even during a marriage. I'd say in most cases, most of the callers that we speak to, it's something that's a outgrowth of the end of the marriage issues, right? As the couple are going their separate ways, as they are becoming more distant from each other, it is very often something that's developing. And so, barring the cases where the person has been abusive or has been controlling, which then the controlling and abusive behavior continues into the divorce in this fashion, there could be other reasons, other things that happen, other changes. Like Jen mentioned, there could be feelings of, well, I'm not getting what I want, or I need to be careful not to give the get because maybe I'll need it in order to get something, a fair settlement. And very often it, some sort of distance that is developing between the two parties that can lead somebody to not care about them, that can lead them to say, I need to do what's right for me. I need to make the decisions that will get me what I need. And I don't need to care if it's hurting somebody else or if it's technically, let's say this Beit Din is telling me it's not okay, but I know that other people are telling me it is okay. And as long as they have that justification, they don't have to see it as doing something wrong. And so I think that makes it a very difficult, sort of treacherous territory. It's gray. There's a lot of gray and nuance, and so it's hard to say, okay, well, I'm going to do the right thing. I'm going to do what some people are telling me is the right thing, but at a cost.
I'm guessing from what you're saying, Jonathan, that it's probably in most cases a get refuser has a group of people behind him, either family or friends, who are encouraging him. And again, I'm guessing that the sole alone loner get refuser is probably a rare species. Probably they have a support staff behind them, so to speak, who are encouraging him and telling him he's not wrong. Am I right?
I would say you are correct. I think not only is it people supporting him, but it's also a general approach saying, I follow this approach. We at Ora definitely believe very strongly what we believe, and we follow the poskim that tell us, that give us direction and halachic permissibility to do the work that we do. However, we are aware that there are other opinions out there, and there are other approaches, and we're trying to work. Again, we're not forcing anybody to agree with us, but we want to appeal to them and say, listen, this process is not working, and this is not, it's the outcome of allowing somebody to delay or allowing somebody to refuse in order to get leverage is not ethical. It is not okay. It is hurting other people. And to recognize the complexity of it, and then to recognize, okay, well, the solution is fairly simple in one sense, is to take the get out of the equation. And let's think about other ways. How can we do an ethical divorce? How can we determine a proper custody, proper financial settlement, and give each party what they should have, or at least, they may both, right, in any mediation, they may both not be happy with the outcome, but that's what's happening here in divorce, in any kind of argument. However, the get itself needs to be taken out.
I mean, it sounds so obvious, and I realize that I'm probably very naive in saying that. It sounds so clear that, of course, give the get at the beginning of the process, remove it as leverage, and then the mediation happens afterwards when that's no longer used as leverage, because that is such one-sided leverage, greater than any other possible leverage that either party could have. On the other hand, people obviously don't think it's so obvious because there are plenty of misconceptions out there. And as you say, there are Beit Din that do things differently. Could you mention what some people believe, what rabbis, communities, Beit Din often are working with, maybe misconceptions or simply different beliefs that can make this problem worse?
One really simple one is that if the get is given right away, then the wife can move on and she won't continue to come to the negotiating table and even resolve other issues. And I think it's just an important procedural aspect to know about this, which is that a couple doesn't receive a get, they receive a p'tor, essentially a receipt that a get was given. And even if a Beit Din does the get at the very beginning of the process, the p'tor that the wife receives, confirming that she got her get, only comes at the end when everything is finalized. So if she's dealing with all issues in the Beit Din, it's once that's done. If she's also dealing with issues even outside in civil court, they'll only give her that p'tor once everything is resolved. And so even just understanding that process can give a little bit of ease, understanding that she's still tied up to the process and isn't going to run away after she receives her get.
Wait, if she does not get the p'tor, what practical ramifications does that have?
She wouldn't be able to remarry. Probably the first question at a new wedding would be, where's your p'tor?
I see. And in theory, should a woman not show up to Beit Din after the get is given in order to complete the mediation, could she be issued a Seruv?
Absolutely. Assuming that a get is issued at a Beit Din, that comes with the assumption that both parties signed what's known as a shtar brurin, an arbitration agreement. And so theoretically, the husband would even be able to take that contract, just like any other contract, and take it to a civil court and ask them to uphold it and say, she's not complying and she needs to appear before that Beit Din.
Now, you've mentioned most of Ora's cases. You've said that a couple of times. So I'm kind of curious when Ora comes in. In other words, what has to happen before Ora gets involved? And then once you do get involved, what exactly do you do?
When somebody reaches out to Ora, they first interact with us through our helpline. Our helpline is staffed by social workers, and we do a fairly thorough intake, trying to understand where along the divorce journey a person is at. Are they just starting out? Are they somewhere towards the beginning in terms of the Beit Din process and the get and maybe a civil process? Or are they further along in a situation of get refusal or delay, as we've been talking about? Once we determine where they're at, we then try to understand, is this a situation that will require advocacy, being referred internally to our case advocates who will then work directly with them one-on-one? Or is it somebody who needs to be followed along or hold their hand through the various earlier stages until they hopefully either get a get or until things get worse? Those initial stages, let's say a caller, what we say a helpline caller, can stay with us for years, and sometimes they do. And we interact with them through email or phone calls to really support them, provide them with referrals, education, and connections to whatever kind of support they need. And we sometimes even reach out to the Beit Din that they may be trying to go to, trying to understand where are things getting stuck. Are there very often miscommunications or just lack of communication between the caller and the Beit Din? And we've been fairly successful through the helpline in helping individuals get gittin. To date, over the past 10 years, we've helped over 140 women get a get just through providing over the phone guidance and holding their hand through the process. If it's a situation that comes to a Seruv or a psak saying that the get has to be given and that we're allowed to ostracize, right, and do our advocacy against the get refuser. So then the person is referred internally to a case advocate. They work one-on-one with them for as long as necessary, and we brainstorm first, how are we going to approach this person, behind the scenes communication, trying to talk to them, understand their perspective, figure out if there's any way to resolve this amicably. And there's always in the backdrop an assumption that if that doesn't work, then we will increase our advocacy and our efforts to convince them and motivate them to comply. All the work that we do, whether it's the helpline or the case advocacy, is free of charge. We don't take money for it because we want to be very, very clear that we represent the get, that we're representing doing the right thing, and we're not representing either side necessarily. If somebody's coming to us saying, I'm not getting a get because they're refusing, or the Beit Din's telling us that, then we're going to step in to try to resolve that issue. If there's other issues that come up, we refer out, help them find the support they need externally, but that's not what we're here to do.
Then let me follow up, because Let's say, for example, perhaps this never happened. I'm just curious what Aura's policy is and how it works. Let's say a woman calls Aura and says, "We decided to get divorced this morning. I'd like you to be involved just to make sure that I'm safe." There's no Seruv, there's no even Beit Din involved yet. This happened literally an hour ago. Is that a case that Aura would take on, or that's not what you're about?
Absolutely. Classically, that's not what OR was about. However, now that we have this helpline, and we want people to know that they should call ORA and they should speak to us, and we can discuss all the different aspects of the stage at which that person's at. So we're not going to take on that case, right? It won't be considered a ORA case that we could put on our website. We're not going to go after the husband for sure. There's nothing there. There's no seruv, there's no psak. However, it's extremely important. It's critical that they call and they ask for help, and we have a conversation, an hour, 2 hours, whatever it is, whatever time they need, and answer all their questions. We recently published as well a get guide, so we can provide them some written materials. And it's so important to arm somebody, right? Knowledge is power. So it's so important to arm them with information and to contain their feelings, right? What are they feeling now as they embark on this process, and all the fears and anxieties and everything? There's a space for that. We can support that. We can tell them, we can empathize, we can validate their fears and concerns, and we can try to normalize everything that's coming up for them. And so I think in a very holistic way, and it's been shown to be very, very helpful in providing somebody with the feeling like they're part of an organization, that they have somewhere to call, they have a support. And for many people, it's outside their community. We get calls from, like, we're part of the Dati Leumi mono-Orthodox community, very much in the YU world. We get calls from throughout the Jewish community. And so very often I'll be on the phone and it'd be somebody from a very exclusive Hasidic community. And suddenly they're heard, they're understood, they finally get it. They know what to do next. And they know that they don't have to do it right away. They can take some time to think. They can they can call this person or that person, and it's very, very empowering. And so the empowerment is critical.
I want to go back to something you said earlier. Just I'm thinking as you're speaking now, Jonathan, about one of the reasons that was mentioned that someone might refuse to give a get. I'm just thinking about it now because I gave that example of we decided an hour ago, that sort of case. And we talked about the importance of giving a get at the beginning of the process. And we said sometimes the reason someone does not want to give it is because he wants the marriage to work. That actually can be a problem here when you say, let's say, for example, the wife leaves a Dear John letter and says, "I want out." He's blindsided. He had never even considered this. We have heard of cases like this. And he says, "I'll give you the get, but let's try and work it out. What can I do?" So in a situation like that, what would Ora recommend happen?
Absolutely. It's such an important and such a common question that we get from callers. And they say, look, I'm ready, but he's not. Or I'm ready and she's not. And what we would say over the phone, of course, we're not their therapist and we don't know them intimately. So this is all over the phone kind of guidance with a lot of disclaimers. What I would say is, number one, these things can take time and it's okay. And in any kind of divorce process, it's important to recognize that you might be at mile 10, but they're still at mile 1, or they maybe even didn't start the race yet, or they didn't even embark on the journey. So you have to know that it's important for your own good to give that person a chance to catch up. Now, the follow-up question is always, well, how long do I give them to catch up? What if they never catch up? So I say, look, you have to give this a little bit of time. Nothing happens overnight. And it's important to build in a little bit of patience into the process. That being said, I say, look, we are here for you now. We're here for you in a week or in a month. Give us a call, check in. Let us be a little bit of your litmus test. When did I call last? Where were they at? Where am I at now? And very often we'll get a call a few months later saying, well, I called you. I've given a little bit of time. He seems to be moving a little bit, but not fast enough, but I'm ready. Say, okay, let's reevaluate. What the decision you made then doesn't have to be the same as your decision you make today. But it's so important to understand why you're making that decision and to make a well-informed decision. And very often, I'll mention also something related to, Scott, what you mentioned about Beit Din. Very often, a Beit Din will say, we don't want to give the get right away because maybe we can have shalom bayis. Maybe we can make it work. The marriage can, the love can be rekindled. And I would 100% agree with that if, with the big if, that's what one or both, really what both people want. If one of the individuals in the couple says, I am done, this is it, I know 100% that I'm not interested in this marriage anymore, so then it's wrong for us to say, well, but we know better. If there's some suffix, if there's some sort of sense of, I'm not sure, I'm pretty sure, so then it is reasonable to say, look, let's talk about it, maybe go to counseling, which is very, very frequently recommended by Beit Din. And at Ora, like, we don't have an opinion on the matter, but it sounds reasonable. I say to somebody, if that feels right for you, okay, see how it works out. But if somebody says, I'm done, I'm 100% sure, so then we're not here to tell people what to do. We at OR for sure not, and we believe that people have the right to make their own decisions.
I get the feeling, and perhaps you're going to tell me this is or is not true, but one of the problems that sometimes does arise is when the Beit Din doesn't stay in its lane. Maybe I'm wrong, but just from stories I've heard, in the example you're giving now, Jonathan, where the Beit Din is trying to do mediation or trying to encourage some sort of mediation or some sort of let's fix this marriage, that may be a wonderful thing, but it may not be their job to even suggest that, never mind try and enforce it. Is that actually a problem?
Staying in your lane is a very frequent issue. And it's something that I think in the rabbinic world we're much more sensitive to today than in the past. I'll answer it a little bit differently to say that many shul rabbis have turned to Ora over the past couple of years as they're learning about the helpline, learning about what we're doing in terms of divorce in general, not just Agunot, to say, look, I don't know what to do here. Can you help with my congregant? Can you help me advise the congregant? So in a parallel way, we haven't had Beit Din reach out to us yet, but in a parallel way, I think it's true. I think a Beit Din should know, and I think many Beit Din do know what is their responsibility and what are they there to do and what is beyond. I think that a lot of things do come up in a hearing in Beit Din, and a lot of important things come up, and it is important to check in with the litigants and say, are we sure? Should we continue? Should we take a break? It's to be real, to be people. The Dayanim are people, and the litigants are people, and you want tzedek and mishpat, and you want it to be done in the proper way. That being said, it's really, really important for the litigants to know, for the man and the woman to know that they should be able to express what they want. And if they know what they want, that should be that somebody's going to hear them and they're going to believe them.
That really speaks to me only because many times on this podcast and elsewhere, I've spoken about a general problem I find often in the Orthodox community, in the rabbinic community, where rabbis, well-meaning, don't necessarily realize what they may not be expert in. And sometimes they can overstep bounds. This is something which is a problem with teachers, particularly in yeshivot, where they may be giving marital advice when they're not therapists and they don't know what they're talking about. And they have to know, I know this and I don't know this. So I'm pleased that you said that, only because I think that this is something which has to be highlighted whenever possible, that people need to, as we said, stay in their lane, know what you know, and also know what you don't know. I'd like to change gears a little bit and speak a little bit about public advocacy. Now, I know ORA has a concept of survivor-led advocacy, so I'd like to know what that means in practice and how that shapes decisions you make in real cases.
Yeah, I think fundamentally it means that the process matters and not only the outcome. And the process of ORA's advocacy or anyone's advocacy can be one that is healing or even harmful. And so, simply put, I think a survivor-led approach means that we're recognizing get refusal as a form of abuse, and therefore the Agunah is a survivor of abuse. And this means that she has been or is in a situation where someone else is controlling her life. They're using their power to control her. And so our process can't mirror that dynamic. And therefore, the Agunah has to be in the driver's seat. So she makes all decisions that impact her life. And to that end, we really present options and not decisions. She gets to make those final decisions. And so if we were to continue making those decisions for her, even if it's not so intuitive, we would kind of be perpetuating the abuse that she's already experiencing. We'd be controlling her life in a way. And so I think a healing process is one where she can actually reclaim agency by making decisions that impact her life, and also allowing her to change her mind over time, and giving her time and space to move on strategies when she's ready.
Okay, you speak about strategies. What kind of strategies are you talking about?
For instance, if we think that organizing a rally, a peaceful protest, might be a very effective way to convince her husband to give a get, we'll present that to her. That might be an advocacy strategy that we want to take. But if she's not comfortable with that, then we're not going to do that. And on the flip side, if she says, I really want to do a rally, but we feel there's absolutely no way that will convince her spouse to give a get, we're also not going to do it. We're not here just to shame someone for the sake of it. We're so sensitive to how serious this work is, and we're not afraid to take bold stances, but we're also sensitive to the implications of doing it. So it can never become lost on us that we're working with real people on all sides.
So, Jen, it sounds like you're saying that the well-known tactic of public pressure is not always the right approach, that it can backfire. Is that right?
I would say yes, and I don't want to undermine it. It's definitely an approach that we use at Aura and that can be very effective, but we're essentially balancing a tightrope where we want to apply just enough pressure where the husband will give the get and not too much pressure where we completely isolate him and he doesn't want to come back to the table where we need him in order to be an active player in giving the get. And so when we're making a decision about what strategy might be effective, we're thinking, what is obviously it has to be a legal approach. Do we have all of the facts straight? Is the Agunah fully on board? But also, like you're saying, that it's highly strategic. So, for example, if we have many cases where the husband is in jail or living out of his car or he's missing or he's living in a community where no one who might convince him to give the get is on social media, that's not necessarily going to be the best strategy. There are other tools that we can use, but it's not necessarily the most effective. But in terms of being counterproductive or backfiring, there can be a situation where it removes any possibility for the husband to feel like he can reclaim any part in the community, that it might actually further entrench him in his recalcitrance and make it less likely that he'll give the get. And so we always just want to be careful, and it's not to undermine it. It's something that we do, but we do it thoughtfully.
And it sounds like, based on what you told me about survivor-led advocacy, it could also be that even if that would work really, really well, and you think that a public pressure campaign would be very effective, if the wife who wants to get does not want that, she's not interested in it, it would be a type of abuse or perpetration of the same type of abuse by doing it anyway. Is that correct?
Exactly. And I'll share it can be really frustrating if we have a strategy that we think would be so effective in obtaining a get, but ultimately we're not here to be in the driver's seat. We're here to provide options and do whatever we can to really help her move forward in whatever way works best for her.
Okay, let's jump down to the idea of the halachic prenup, which I've spoken about before on this podcast, probably with you, Jen, at certain points. But I'd like to know what the halachic prenup actually does, and to what degree has it not become a universal norm, and why?
Yes, it's a really great question. And there are different versions of the halachic prenup out there, but fundamentally, there are two components to it. So, not to get too in the weeds, but the first part is that it's a binding arbitration agreement. And so, really, in light of everything we've shared here about how hard it can be to get a divorcing couple to agree about where they want to go to address their divorce, about what Beit Din they want to go to, it completely circumvents that problem by saying, if my spouse and I would ever have to deal with this issue of the get, we're just deciding in advance where we would go to deal with that issue. So that's the first part. The second part is a financial support obligation. And so the version that we often use at Aura is actually reciprocal. And so it says if either person isn't cooperating in the get process, they would have to pay a certain amount of money to their spouse until the get is given. And so the point of that is it creates this financial disincentive for get refusal, and it's been highly effective.
Isn't that at least implicit in the ketuvah itself in every marriage? Because it says that as long as you're married, the husband must support his wife. So at least from that side, from the husband refusing to give get to his wife, he is required by halacha to give money to his wife, even without a halachic prenup. Is that correct?
So it's based on the Rambam's Mizonot obligations. And I'm so glad you brought that up because sometimes a concern might come up. Is this a financial penalty for not giving the get? Because that might make the get invalid. And so exactly like you're saying, there is this halachic concept that during a marriage, a husband has to support his wife in, 10 different ways, and including giving her food and clothing and shelter and all sorts of things. And so in a typical marriage, the Beit Din isn't overseeing that and making sure that's happening. But in divorce situation, if someone is not giving the get after a Beit Din says that it is appropriate to do so, then in this backwards kind of way, they're saying, I still want to be married to you. And so in that situation, a Beit Din can come in and say, as long as you choose to do so, we're going to make sure that you're fulfilling your halachic obligations.
So that's essentially what this halachic prenup is doing. It's basically formalizing and making legal the obligations that are already explicit in the ketubah. Is that a fair way of saying it?
I think so. And the ketubah is also not civilly enforceable. And so some have also said, is this redundant to the ketubah itself? But it really isn't, especially for that reason, because this is a document that's also civilly enforceable.
Now, in your opinion, I realize there isn't an objective answer to this, but let's say that the halachic prenup were universally adopted. And at this point, let's acknowledge that there are different verses, different girsaot, different poskim like this one or that one, or don't approve of this one or that one. Let's talk about the one that Ora uses. If the prenup were universally adopted, how much of the current problem of get refusal do you think would disappear? Would it essentially put Ora out of business in a good way, or is it very far from being foolproof?
I would say most of the problem actually would disappear. It obviously can't protect in every situation, like God forbid, a classical Agunah situation, if someone is missing or lost, or theoretically, if someone has, we say, too much money or no money at all. However, that hasn't really been an issue in the past. But for the most part, I do think it would completely change the landscape here. And that universal adoption of the halachic prenup in combination with a community that strongly upholds Seruvim for the few cases where there might be an issue, I think would be the strongest protection against get refusal. And I also think it's kind of a litmus test for relationships because it is an insurance policy that does protect couples in the event that they need to use it. But it kind of has culture change baked into it because by signing it, you need to talk about it and you need to reflect on your values and you need to express that the get is not something that you would ever be willing to use as a weapon against your spouse. And so you would also need more Beit Din to be willing to enforce it. And so that actually could create a massive culture shift within the process and one that we've really already seen within the modern Orthodox community.
And people who are afraid of how could I talk about divorce when I first get married, I have mentioned to people before, it sounds obvious, but it's important to say, if you sign a ketubah, then you're talking about divorce because that's really what it's about for the most part. So it's not as though this is a new innovation that suddenly in the 21st century, we're forcing a couple when they get married to talk about divorce. It's been going on for thousands of years.
Exactly. Well said.
Okay. I have two more questions for you. One of them goes back to the very beginning of our conversation, and you mentioned that Ora's work is primarily in North America, but it makes me think about some of the major differences between North America and Israel. Of course, there are places in the Jewish world that are in either place. I'm not trying to ignore those places, but given what we're talking about today, primarily your work is in North America. Do you think that these problems in Israel are greater or worse given the connection of the Beit Din to a literally legal enforcement mechanism? In other words, the Beit Din are a government agency in Israel, and therefore they have greater powers of enforcement. Someone can go to jail without going to a civil court, just because that's part of how it works in Israel. But there are all sorts of other problems that also includes. So in your opinions, do you think that the problem is exacerbated in Israel or lessened in Israel? To hear the fascinating responses that both Jen and Jonathan provided to this question about the difference between Beit Din in Israel and outside of Israel, become an Orthodox Conundrum Commentary paid subscriber. The link is in the description of this podcast. Now, as my final question, I'd like to ask, whether we're talking about North America, Israel, or anywhere else, if you could tell us what things need to change fundamentally in the get process, in the divorce process, how do we get to a place where, apart from adding the halachic prenup, which seems the most obvious case, but apart from that, which we've already talked about, what are the things that need to happen socially, culturally, even on an individual level in order to allow this process to, as I say, in a best way possible, put ORA out of business?
There are a couple of things I like to say. I overall have an optimistic view on life. And so a few of the things that I would say here, number one, is that there needs to be a general movement towards standardizing procedures. Procedures should be standard in across the board in Beit Din. And although that's a very, very difficult thing to do, right? Two Jews, three opinions. I think it's something which needs to happen. specifically within this area, but also within other areas that the Beit Din is involved in. But they did, and there needs to be some sort of consensus, at least in how we go about doing something, even if we hold different opinions and shitos on different matters. There needs to be a collaboration and communication between Beit Din and between Beit Din and advocacy organizations. I like to believe at ORA we work very well with many Beit Din, and we have a good relationship with them, and there's trust, and there's we look up to them in terms of the work that they're doing and the important aspect of following halacha and helping couples resolve these end of marriage disputes. In addition to that, I think I like to say, quoting the Rambam, right? What is avoda me'ava? It's oseh ha'emet mipnei shu emet v'sof ha'tov lavo. In a sense, we want. I think what fundamentally has to change is that people, whether it's the Beit Din or whether it's the individuals themselves, need to do the right thing. And at ORA, we often talk about doing the right thing. And even if doing the right thing means that you forfeit something, it's still the right thing. And it's a message to your children, it's a message to your community, to your family, to anybody who's looking at you, or anybody who's watching from the side, that somebody did the right thing. And here it's a very big ask. It can be a very big ask to forfeit leverage and to go against perhaps what people are telling you to do within your best interest. However, it's the right thing. And I think that's a fundamental change that has to happen. I'm optimistic, but I think it may take a lot of work to get there. But I do believe that it's fundamentally what we believe in.
God willing. Okay, Jen, let me give you the last word.
As a community, if we recognize get refusal as a form of domestic abuse, which is definitely our understanding at ORA, it really shifts the way that we respond to it. And then a lot of the other pieces hopefully would trickle from there. And domestic abuse is defined as a pattern of controlling behavior. And a study has even shown that Agunot have experienced 3 or more other forms of abuse during their marriage. There's really data to back this up. But fundamentally, what's underpinning any situation of long-term get refusal is the desire to control, for the husband to say, it's in my power to control if you can get remarried, if you can have more children, if you can move on. And that's leverage that could come in big or small ways until the get is given. And so I think it matters if we define get refusal as a form of abuse, because then it will shift our comfort in responding to it. I think for all of us, divorce is not something that we want to get involved in, and there are more than 2 sides to every story. But if we understand that once there's a Seruv, that means that someone actually crossed a line, they're doing something abusive, then it makes it more comfortable for us to respond. It gives us that clarity that we need in order to say, I'm comfortable upholding a Seruv. I'm comfortable signing a halachic prenup and making sure that this is not an issue in our community. I want to adopt bylaws in my shul or in my school that outline what would happen if there's a get refuser here. It really enables us to be very values aligned as we're responding. And just like any other form of abuse is not something we would ever tolerate, it helps fit it in that mold and gives us a little bit more clarity when we need to respond to it when it does show up.
I'm so glad that you mentioned that, Jen, only because we often hear in a terrible example how rape, for example, is not about sex, it's about control. And what you're saying now, it's in the same category in some larger sense. It's just about control. As much as we're saying he wants to get leverage, ultimately it's about control, and it's the same category as domestic abuse. I think that's such a terrible but important point, and I'm glad we mentioned it. So I'm sorry we had to have this conversation, but I'm very glad that we had this conversation. Rabbi Jonathan Hefter, Jen Lankin, thank you for joining me.
Thank you so much.
Thank you very much.
I'd like to offer a word of thanks to our Patreon supporters. Patreon functions as a voluntary tip jar for Jewish Coffee House and our family of podcasts. Patreon supporters at all levels, as well as paid subscribers to Orthodox Conundrum Commentary, will have access to our upcoming private Q&A sessions. Your support in either place helps sustain thoughtful Jewish conversation. Additional bonus material, including the longer episodes with bonus questions, is available to paid subscribers of Orthodox Conundrum Commentary on Substack. No matter how you choose to support this work, we are deeply grateful. Subscribe to the Orthodox Conundrum podcast wherever you get your podcasts, and please rate it and write a review. I'd appreciate it if you go to Apple Podcasts and rate and review the Orthodox Conundrum. It takes literally 2 minutes. It's just giving a certain number of stars and writing 1 or 2 sentences. Please like the Orthodox Conundrum podcast on Facebook and join our growing Facebook group, the Orthodox Conundrum Discussion Group, where you can feel free to discuss issues in Orthodoxy in an honest and friendly environment. Subscribe to my Substack, Orthodox Conundrum Commentary. Check out the link in the description of this podcast to get your free subscription today. Finally, do you have a message that needs to get out? Do you want to promote your business, your organization, or your cause? The best way is by producing a podcast, and Jewish Coffee House can make it happen. I have experience producing hundreds of podcasts, both for myself and for satisfied clients. Whether you want to learn everything you need in one day, or relax and record and let me do the heavy lifting, Jewish Coffee House Productions will work with you to make it happen and make it even better than you imagined. Let me help you today. Write to us at aliza@jewishcoffeehouse.com. That's ALIZA @jewishcoffeehouse.com. And let's get started with your high-quality, memorable, and effective podcast. I'm Scott Kahn. This has been the Orthodox Conundrum on jewishcoffeehouse.com.